If you have a baby in a military hospital and that baby is injured at birth, can you bring a birth injury lawsuit? In previous videos, I discussed military claims against hospitals under what's called the Federal Tort Claims Act, and I'm going to put a link below to those videos. But in this video, I'd like to explain to you that you can bring a birth injury case against a military hospital, even if you are on active duty, because you're really bringing a case on behalf of the child. Now, since you're on active duty, you can't bring a claim for yourself. Previous video, I explained why that active military people cannot bring lawsuits against military hospitals for medical malpractice, but this is different. If your baby has been injured, your baby is not active military, obviously, and there would be no bar for that baby to be able to be compensated if medical malpractice has been committed upon you during the labor and delivery, resulting in brain damage to your baby. Now, there are a lot of procedural differences between a case that's brought against a military hospital, known as a federal tort claim, and one that is brought in a traditional court. And one of those is the type of notice that has to be given. So in a military-based hospital malpractice case, you have to give notice to the branch of federal government within 2 years. That's a form that has to be filled out. I don't recommend that you do this form yourself, although it's possible. But in any kind of case like this, I would always suggest that you get an experienced medical malpractice lawyer to help you with this form, because if you don't fill out the form properly or you don't send it in properly, you will not be allowed to bring a lawsuit. So I hope this information is helpful. I get a lot of questions about military hospitals, who can bring a lawsuit and who can't bring a lawsuit. But if you have a baby that's been injured, you can bring a lawsuit against a military hospital.